Mr. Grossman was alderman of the city of Toronto from 1952 to 1955 and was a charter member of the Metropolitan Toronto Council. He was a member of the Legislative Assembly of the Province of Ontario from 1955 to 1975, and during that period of time was the minister of many of the ministries. He was a minister without portfolio from 1961 to 3, and then was Minister of Reform Institutions, Minister of Trade and Development, Minister of Revenue, Provincial Secretary for Resources Development. He was also Vice Chairman of the Treasury Board, and on, and more importantly for us, he was appointed Chairman of the Criminal Injuries Compensation Board in January of 1976, and is former Chairman of the Canadian Association of Crime Victims Compensation Boards. And it's a great pleasure that I introduce Mr. Grossman to you.
Thank you very much, Mr. Noble. Very pleased that I was invited to participate in this series of lectures, and I hope that I'll be able to be of some help to you. Can you hear me down at the rear there? You're tough luck. Well, first, as to the philosophy prompting the policy of compensating victims of violent crime, generally speaking, it's based upon the principle of the fulfillment of a duty of a state to protect its people from injury or untimely death, and two, putting the onus upon the state not only to punish the offender, but to compensate victims who generally will have no other source to look to for such compensation. And three, the sense of responsibility which a humane society feels or should feel for victims of crime, particularly crimes of violence. Now, one could give a half an hour discussion on the philosophy of this work, but in a nutshell, that will really give the picture, I think. We're living in an era in which society recognizes many obligations which it never felt compelled to in other times. A somewhat analogous recognition of this obligation in many jurisdictions is the compensation for pecuniary loss paid by the state for persons injured or killed through negligence of uninsured car drivers. Unless the state assumes responsibility for innocent victims of crime, most such victims, in fact, the vast majority of such victims, will not be compensated. Because it's wise to keep in mind also that it is generally the poor, and therefore judgment-proof, who commit crimes of violence. And incidentally, it's also generally the poor who are victims of such crimes. Your Ontario government was among the first jurisdictions in the world to initiate a program of compensation for victims of crimes of violence. In 1964, New Zealand established the first scheme. The United Kingdom, California, Saskatchewan, and Ontario followed shortly thereafter. All of the Canadian provinces, as well as an increasing number of American states and other jurisdictions, now have such a program. In Ontario, the Law Enforcement Compensation Act 1967 was given royal assent on June the 15th, 1967, and proclaimed in force on April the 1st, 1968. Under that act, the board was restricted to awarding compensation only where a person was killed or injured assisting a peace officer. The act was amended in 1969, the amendments being given royal assent on June the 27th, 69, and being made retroactive to April the 1st, 1968. The amendments broaden the act so that compensation may be paid not only where a person is killed or injured assisting a peace officer, but also where the person is simply a victim of a crime of violence. In September the 1st, 1971, the Law Enforcement Compensation Act was superseded by the Compensation for Victims of Crime Act, and the title of the board was changed from the Law Enforcement Compensation Board to the Criminal Injuries Compensation Board. The board is a corporation to which the Corporations Act does not apply. It is composed of such number of members, not fewer than 5, as are appointed by the Lieutenant Governor and Council. and the Lieutenant Governor and Council appoints one of such members as chairman and one or more of them as vice chairman. The board, as of this date, comprises 11 part-time members, including 2 vice chairmen and 1 full-time member, the chairman. The present part-time members represent a cross-section of society: 4 housewives with various backgrounds, such as teaching, community work, etc., 4 lawyers, 1 retired, a school teacher, and 2 businessmen, 1 retired. The staff of the board numbers 13, including a registrar, a chief of investigation, and 3 investigators, as well as clerical and secretarial staff of 8. Injuries are compensable where any person is injured or killed by any act or omission in Ontario of any other person occurring in or resulting from A, the commission of a crime of violence constituting an offense against the Criminal Code Canada, including poisoning, arson, criminal negligence, and an offense under Section 84 of that Act, but not including an offense involving the use or operation of a motor vehicle other than assault by means of a motor vehicle. Lawfully arresting or attempting to arrest an offender or suspected offender for an offense against a person other than the applicant or his dependent, or against such person's property, or assisting a peace officer in executing his law enforcement duties, or C, preventing or attempting to prevent the commission of an offense or suspected offense against a person other than the applicant or his dependent, or against such person's property. Those who are eligible to receive compensation as a result of a crime of violence include the victim, the person who is responsible for the maintenance of a victim, and where the victim has died, the victim's dependents or the person who was looking after the victim before his death, or the person who has incurred an expense on behalf of a victim or his estate and not being required by law to do so. Compensation may be awarded for A, expenses actually and reasonably incurred or to be incurred as a result of the victim's injury or death. That includes funeral expenses up to a maximum presently of $1,200, which may be awarded under this particular subsection. B, pecuniary loss incurred by the victim as a result of total or partial disability affecting the victim's capacity for work. Pecuniary loss incurred by dependents as a result of the victim's death, pain and suffering, maintenance of a child born as a result of rape, other pecuniary loss resulting from the victim's injury, and any expense that, in the opinion of the board, it is reasonable to incur. The applicant must apply for compensation within 1 year of the injury or death, though under special circumstances, the board will consider the reasons for late filing and may extend the limitation period. Section 6 of the Act reads, "An application for compensation shall be made within 1 year after the date of the injury or death, but the board, before or after the expiry of the 1 year period, may extend the time for such further periods as it considers warranted." In the case of the limitation period having expired, an extension of limitation period form is provided to the applicant. Upon receipt of the duly completed form, the board will consider the reasons for the delay. I would point out, Mr. Chairman, that the limitation period is not affected by the date of conviction. This is a common misunderstanding, and I regretfully say also on the part of some lawyers. The limitation period is not affected by the date of conviction, since the Act prescribes a limitation period of 1 year from the date of the alleged offense. A fair number of such requests would indicate that much of the delay is caused by an oversight, or in some cases, even an apparent lack of knowledge of this section on the part of lawyers representing clients. This has some implications which may get some lawyer into trouble someday, and I think by and large the only reason that hasn't happened, that a lawyer has not been sued by a client, is probably because we refuse, and only in very few instances, to permit an extension because of the fact that we hate to see anyone, merely because of some neglect on somebody else's part, having to suffer because of that. Upon inquiry regarding a proposed claim, and assuming the date of the occurrence is within the limitation period, a regular application form is mailed or given to the applicant or his solicitor for completion. Accompanying the application form is what we term a guide to applicants, which explains in simple language the procedures to be followed. Where it appears that the applicant does not appreciate what is required of him, or doesn't know how to go about obtaining the documentation required in support of his claim, or has no legal representation, the board will take the responsibility of obtaining the necessary documentation and of even paying the cost of same. The applicant is quite frequently invited to visit the office personally, where our courteous staff members will assist him or her in such situations. Of course, where an applicant is represented by counsel, all the supporting documentation is processed in a more professional manner as between the board and counsel. I should point out that whereas up until about 6 or 7 years ago, there were very few of our applicants represented by counsel, I would think that now it's over 50% who are represented by counsel. The applicant or his counsel is advised, upon receipt of the duly completed application form, of the documentation required. Generally, this will consist of receipts of bills for out-of-pocket expenses, doctors' or dentists' reports, copies of hospital medical records, employer's statement re loss of wages, and a declaration of any monies received as a result of the injury or death, and any other proof as may be necessary to allow for a full appraisal of the occurrence and its consequences. It's important to have an up-to-date medical report by a physician who is familiar with the injuries from having treated the applicant. Most medical and hospital expenses in Ontario, as you will appreciate, are paid by OHIP and are therefore not recoverable from the board, which does not duplicate payments of any kind. Loss of wages, in many cases, are covered by Workers' Compensation Board in instances where the offense occurred while at work. The board pays net loss only, and the proceeds are not taxable. As soon as all the documentation has been filed, the board will place the application on the list of cases ready to be heard, and a date will be set for a hearing shortly thereafter. Applications are received by the registrar of the board and immediately passed to the investigation personnel for action. A report is requested from the law enforcement agencies concerned, and the process of collecting and analyzing all other information required in the support of the claim begins. In the latter case, direction is provided to the applicant or his solicitor. Field investigation may focus upon sections 5, 17, and in the case of a review, which would be after an award is made, section 25. I should point out that sections 5 and 17 deal with the right of the applicant to have a review under certain circumstances with which I'll deal later. And section 25 deals with an application for the variation of an award, which I will also deal with later. The file is examined to determine as to whether the circumstances, as outlined by the applicant, appear to be such as to lead to the conclusion that some actions on the part of the applicant might be of interest to the panel who will eventually hear the case, with particular respect to sections 17, subsections 1 and 2, which read as follows. 1. in determining whether to make an order for compensation and the amount thereof, the board shall have regard to all relevant circumstances, including any behavior of the victim that may have directly or indirectly contributed to his injury or death. 2, the board may, in its discretion, refuse to make an order for compensation where it is satisfied that the applicant has refused reasonable cooperation with or failed to report promptly the offense to a law enforcement agency. That's very important. From the foregoing, it's obvious that the board expects that the crime should be reported to the police promptly, followed by the laying of a charge. The board looks very searchingly, as it is directed to do by the Act, into situations where the victim has not reported the occurrence promptly to the police, nor cooperated fully with them. Such cooperation is important, giving police a better opportunity to assess the circumstances of the alleged attack and apprehend the offender. Obviously, the legislature included these subsections to ensure that the disbursement of public funds in this act is restricted to proper and deserving cases. The board will, in some instances, while not denying award, reduce the amount to be awarded. And as I said earlier, some instances will deny an award completely when this section is invoked. It might be interesting to point out that as of their last fiscal year, we granted awards in 977 cases without any reduction. 128 were denied completely, and 57 were awarded reduced awards. When a field investigation is completed, the investigator prepares a report which forms part of the file and which is provided to the applicant or his counsel prior to the hearing. A copy is also provided to the offender or the alleged offender, if it is possible to provide it, if he's around, or will be able to be in a position to receive mail. Reference is made to Section 16 of the Act, where it is seen that a conviction is not always essential for an award. For example, of course, in many instances, the offender is unknown or not apprehended. The board may decide that a crime was committed whether or not the offender, known or unknown, was prosecuted and or convicted. This particular section reads, an order for compensation may be made whether or not any person is prosecuted for or convicted of the offense giving rise to the injury or death. But the board may, on its own initiative or upon the application of the minister, adjourn its proceedings pending the final determination of a prosecution or intended prosecution. And 2, notwithstanding that a person for any reason is legally incapable of forming criminal intent, he shall, for the purposes of this act, be deemed to have intended an act or omission that caused injury or death for which compensation is payable under this act. I think that's pretty clear what that refers to. People are of unsound mind, and the legislature is anxious to make sure no innocent victim suffers because he happens to be injured as a result of the actions of such a person, or a child who's not responsible for his actions. The burden of proving a criminal offense before us is less onerous than in a criminal court. The standard of proof is on the balance of probabilities, and not as in a court of law beyond a reasonable doubt. Evidence is available to our board which cannot be presented in a court of law. For instance, the offender may have given evidence at an inquest under the protection of the Canada Evidence Act or the Ontario Evidence Act, which cannot be used against him in a subsequent criminal or civil proceedings, but it is admissible before our board. Hearsay evidence is admitted. The board, in case of dire need, will, in some instances, provide interim payments to an application. Section 14 of the Act reads, where A, the applicant is in actual financial need, and B, it appears to the board that it will probably award compensation to the applicant, the board may, in its discretion, order interim payments to the applicant in respect of maintenance and medical expenses, and if compensation is not awarded, the amount so payable is not recoverable from the applicant. The present maximums in respect of a victim are A, a lump sum payment of $15,000, or B, periodic payments not to exceed $500 per month. The board may also award a combination of lump sum and periodic payments. And the Act reads that the amount awarded by the board to be paid in respect of the injury or death of one victim shall not exceed, A, in the case of lump sum payments, as I referred to, of $15,000, and in the case of periodic payments, $500 a month. And where both lump sum and periodic payments are ordered, the lump sum shall not exceed half of the maximum, therefore prescribed in Clause A. In other words, $15,000 lump sum payment, but where there is, in addition to that, in addition to a lump sum payment, payments ordered on a periodic basis, monthly payments, then we can only award to a maximum of $7,500 lump sum and up to a maximum of $500 per month. The total amount awarded to be paid to all applicants in respect of any one occurrence shall not exceed, in the case of lump sum payments, a total of $100,000, and in the case of periodic payments, a total of $175,000. We have generally restricted awards of periodic payments mainly to widows with children or to other deserving cases where the claimant was seriously wounded or permanently crippled, and to minors who, it appears, will need regular payments for maintenance, schooling, etc. Section 17.1, which I've already referred to under the head investigation of claims, can cause concern particularly in assault cases where the victim was intoxicated. Having regard to all relevant circumstances, and including any behavior of the victim, the hearing officers have reduced awards where they decided that such intoxication contributed to the victim's injuries. Drunks, as they say, are easy marks for muggers, and we take the view it is asking for trouble to stagger through streets at night under the influence of alcohol. If the applicant engaged, for example, voluntarily in a free fight, we may even reject the claim. If, for example, an applicant began a fight on equal terms, and one participant pulled a knife and used it, a reduced award would possibly be made in a situation like that. Every case, of course, must be determined on its own particular circumstances. Now, with regard to the hearings themselves and parties to the proceedings, the Act reads that the board or member to whom an application is referred shall fix a time and place for the hearing of the applicant, and shall at least 10 days before the day fixed cause notice thereof to be served upon the applicant, upon the minister, upon the offender where practicable, and upon any other person appearing to the board or member to have an interest in the application. And to every person upon whom notice of a hearing is served, and any other person added by the board is a party to the proceedings. Notice of hearings are sent by registered mail. All applicants are entitled to a viva voce hearing. Incidentally, Ontario is one of the few jurisdictions in the whole world which provides this entitlement. Sittings in Toronto are held in the board hearing room at 439 University Avenue 4 days a week, Tuesday through Friday. Sittings also are held in out-of-town locations where the volume of cases from an area permits such an arrangement without occasioning unreasonable delays for applications ready to be heard. As a rule, 4 applications are heard on each hearing day. During the last fiscal year, hearings, in addition to those held in Toronto, took place in Fort Frances, Thunder Bay, Sudbury, Sault Ste. Marie, Windsor, London, and Ottawa. This is done to facilitate applicants and to generate a better understanding of the work of the board across the province. Hearings may be conducted by 1 or more members of the board. The board usually sits in panels of 2. In simple cases, the board, with the consent of the applicant, will deal with an application on documentary evidence exclusively. Our authority to do so is contained in Section 4 of the Statutory Powers Procedures Act. And in the last fiscal year, some 107 cases were dealt with on this basis. If the applicant or his counsel does not appear at the scheduled time of the hearing, the board, in accordance with Section 7 of the Statutory Powers Procedures Act, may proceed without him and consider the claim on the basis of the documentary evidence before it. And I should say here parenthetically, we try to avoid that where they don't appear, either one doesn't appear, we get a member of the staff to try to locate them and find out if there's a particularly good reason for it, as can happen and has happened in such cases. In other words, we're not arbitrary about that, but we don't want to clutter up our hearing lists and keeping a lot of other applicants waiting for hearings because somebody thought they'd rather go someplace else and not bother appearing. All our hearings are open to the public, except in those instances where it appears desirable to hold them in camera in accordance with Section 12, which reads, "All hearings shall be held in public, except where, in the opinion of the board, it is necessary to hold the hearing in camera for the reason that a public hearing, A, would be prejudicial to the trial of the person whose act or omission caused the injury or death, or B, would not be in the interests of the victim or of the dependents of the victim of an alleged sexual offense." And brought to mind of a situation where we made an award to a very aged couple who had the practice of, well, they didn't trust banks. They kept a lot of money on hand in a very small community. And they were robbed, beaten and robbed. And they were robbed of some many thousands of dollars. They knew the young people who had attacked them and robbed them. There's no way they could prove it. There just wasn't any way they could prove it. That was established. It was decided that if the hearing was public and if the results of the hearing were made public, the same people would know that this couple is going to be receiving a check, receiving checks for the rest of their lives. And we thought it would be advisable not to let them know, so we declared the hearing. We held the hearing in camera and did not allow publication. And the board is permitted to prohibit publication under Section 13 of the Act, which reads which reads that they may, if some of these circumstances are referred to, particularly sexual attack, to prohibit the publication of any such report, and there are appropriate sanctions if such is not respected. Members of the panel have before them a brief comprising copies of the documentary evidence submitted in support of the claim. The brief may also contain an investigator's report, a copy of which will have been given to the applicant and or his solicitor prior to the hearing. The applicant will have been advised to study the report, and should he feel that he has not had sufficient time to study its implications, he may request an adjournment, which will be granted. The hearing will commence with the applicant being sworn in. Should the applicant require a translator, and the board is advised prior to the hearing, one will be made available. No transcripts of the proceedings is kept. Quite often lawyers will ask for a copy of the transcript, but there is no such thing. The informality of the board would go down the drain if we set up a machinery for that sort of thing, and we would never be able to hear anywhere near the number of cases that should be heard, and they would pile up for many years. After considering the evidence before it, the testimony of the applicant, the offender or alleged offender, and other witnesses, the board will usually take a short recess to consider the case. When they have arrived at a decision, the applicant will then be advised of an award, including the specific amounts in total. Should an award be denied or reduced, the panel will advise the applicant of its reasons. Incidentally, when I refer to the applicant here, we mean the applicant or his counsel if he's represented by counsel. A copy of the board's decision is mailed to the applicant and or his counsel, usually within 2 or 3 weeks after the hearing, together with payment, if any. If the offender attended at the hearing, a copy of the decision will also be mailed to him. There have been a number of instances where lawyers have submitted a direction to the board, duly signed by the applicant, that the award be paid to other than the applicant. Section 20 of our Act states that, quote, any money paid or payable by way of compensation under this Act or held by the public trustee or any other person under an order made by the board is not subject to garnishment, attachment, execution, set off, or any other legal process, and the rights thereto is not assignable. End of quote. Therefore, the check and payment of the award is sent directly to the awardee as set out in the order. Section 21 of the Act reads, if a person entitled to an award under this Act is under the age of 18 years or is of unsound mind or in the opinion of the board is incapable of managing his own affairs, any amount payable to him, incidentally, if any ladies present, this is the way the Act reads. Don't blame me if I don't keep saying him or her, eh? Any amount payable to him may be paid on his behalf to his parent, spouse, or comite, or to the public trustee, or may be paid to such other person, or applied in such manner as the board considers in the best interest of such person. And amounts so paid shall be received and administered by the payee for the benefit of the person. End of quote. In respect of minors, lump sum payments are usually paid to the accountant of the Supreme Court of Ontario, and periodic payments are paid to the public trustee. However, when a lump sum payment in respect of a minor is not in excess of $2,500, the board may direct payment to be made to a parent or guardian to be used for the benefit of the victim. The board uses its discretion depending upon the particular merits of each case. For instance, it has made awards for what would normally be lump sum payments to be paid on a monthly basis to ensure that the monies so awarded are used for a specific need. That is, for tuition, other such incidentals, so on. The board awards modest legal fees. Some of you who come before the board know that. Awards modest legal fees to solicitors who represent claimants for preparation of cases, completing forms, and collecting supporting material to be submitted with the application. Disbursements, of course, are also reimbursed. In cases where a claim is not successful, the board may or may not award legal fees and disbursements, depending on the circumstances. This is done under Section 22, which reads, notwithstanding Section 19, which deals with maximum payments, the board may, with respect to any hearing or other proceeding under this Act, make such order as to cost as the things fit. In other words, costs could be awarded to counsel even when an applicant is granted the maximum payment, or in some cases, when representing the offender. A legal fee is not usually awarded to a student at law nor to representatives of legal aid community centers who, as you know, are otherwise funded. The matter of subrogation under Section 26 is of particular interest to offenders or alleged offenders. Once an award is made, the board is subrogated to all the rights of the person to whom payment is made to recover damages by civil proceedings in respect of the injury or death, and any amounts recovered by the board shall, in accordance with the Act, be applied to payment of costs actually incurred in the action and in levying execution, and to reimbursement of the board for the value of the compensation awarded. In regard to such civil actions, the Act reads, "An applicant for or a person awarded compensation shall forthwith notify the board of any action he has brought against the offender who caused the injury or death of the victim." In practice, we notify the Attorney General's office of all cases where we believe recovery can be made from the offender. The matter is then followed up by the law officers of the Crown on our behalf. The fact remains that, as previously mentioned, the great majority of offenders are judgment-proof. Many are incarcerated for various periods of time, and most cannot be located at all. It is the policy of the board to use every effort where possible to have the offender reimburse the taxpayer. In most cases, where possible, and before initiating civil proceedings against the offender, the Crown Law Office will contact the offender and advise him of the circumstances, and if the offender prefers, arrangements are made for him to make payments to the board as and when he can. In fact, this is what happens in almost all instances where subrogation is recommended by the panel hearing the case. Such recommendation is usually made where the hearing officers, after some questioning, decide that the offender is financially in a position to pay. Incidentally, how difficult it is and the kind of people we're dealing with is reflected in the fact that during the last fiscal year, out of $2.5 million paid in, some $2.5 million paid out in awards, we were able to get $31,000 back, which was a great improvement over the previous year when we were able to get $12,600. As to review procedures and so on, where an application is heard by a single member of the board, the applicant or the minister may I'm quoting from the Act now, the applicant or the minister may within 15 days after the service of the decision of the member require a hearing and review by the board. The board will then fix a time and place for the hearing and will at least 10 days before the day fixed serve notice upon the parties to the proceedings. The hearing then must be conducted by at least 2 members, and the member whose decision is being reviewed must not sit on the review. The board will then make its order in accordance with the Act, and its order supersedes the order of a single member. The decision of the board is final, except that an appeal lies to the division court on any question of law. However, under Section 25, the board, on its own initiative or on the application of the victim, any dependent of the victim, the minister, or the offender, may vary an order for payment of compensation in such manner as it thinks fit, whether as to terms of the order or by increasing or decreasing the amount ordered to be paid otherwise. The board shall consider under such circumstances any new evidence that has become available, any change of circumstances that has occurred since the making of the order, or any variation thereof as the case may be, or that is likely to occur, and see any other matter the board considers relevant. For example, medical problems which develop later on, which were not foreseen by the board during the hearing, which develops later on, anytime later on in life, and it can be established to the satisfaction of the board that that is part of what the result was of the incident which took place. In other words, a person may have a deficiency of his eyesight caused by an injury, and at that time the medical people didn't think it was going to get any worse. 10 years later, if a person loses his sight completely, that person come again before the board and ask for a variation of the order, and if that can be established, that would be taken into consideration. Probably an increased order made. In other words, no file at our board is really ever closed. It can always be reopened under a variation. Now, over the years, the board has sought by various means to make the public aware of its activities. Most of its publicity comes from news reports resulting from copies of the board orders sent to the media. The board also provides posters and explanatory brochures in several languages, distributed throughout the province and placed in such locations as hospital emergency wards and staff lounges, courtrooms, libraries, and shopping plazas. In addition, the board provides police departments with wallet-sized cards, which give basic information about the board. These cards are designed to be given to victims of crimes of violence by a police officer who may or may not be involved in the investigation of the occurrence. In fact, a very large and increasing number of applicants have been so referred to the board. Now, ladies and gentlemen, I have deliberately left the problems relating to pain and suffering to the last, because I'm most anxious to point out some of the difficulties which continue to arise as a result of some confusion, at least on the part of the public, in this respect. Pain and suffering is usually, but not always, the head requiring the greatest amount of the board's attention, as well as resulting in the larger portion of the awards. Matter of fact, the figures are, I think this last fiscal year, 70% of the awards were for pain and suffering. 70% of the amount of the awards was for pain and suffering. It is the only award the board is authorized to deal with in the field of general damages. However, this raises questions before the board which do not arise in a practical way in the courts. For instance, the distinction between loss of amenities of life on the one hand and pain and suffering on the other. A judge presiding in a civil action has before him adversaries who argue the facts for a plaintiff and a defendant, thus making it somewhat less difficult to arrive at a balanced conclusion. It's not easy, as I'm sure you'll understand, to apply any rigid rule to a standard of damages. Also, you'll appreciate that before you appear in court, your cases are well researched. They should be. Lawyers for both sides will have delved into records of precedents and will present their findings to make their case. If our board were to do the same kind of research in dealing with our applicants, we would have to have a tremendously larger staff. It would never be able to deal with the applicants in as short a period of time as it does. And rather than hear 4 cases a day, perhaps it would be able to hear only perhaps 1 case in 4 days. That, of course, was not the intention of the legislature in instituting the program, particularly when one takes into consideration the relatively small maximum amount that the board's able to pay. I suppose the board's equivalent of Goldsmith's report on damages on personal injuries and death, which I believe is commonly used as a reference by your profession, is the list of brief details about 400 awards contained in our annual report. Those of you who have seen our annual reports, we summarize about 400 cases. The system is we take every other case and it goes in, it's summarized and put in our annual reports so they can be read by the profession and others interested. The board keeps a record of the amounts awarded for certain types of injuries for the previous year. The panel hearing a case has access to this schedule should they feel the need to refer to it. That is, for example, a simple fractured jaw, well, if one can call a fractured jaw simple, without any complications, may call for maybe $500, $750, or $1,000. Where there are complications which arise from that injury, having regard also for the nature of the attack which caused the injury, the board members may award a higher figure for pain and suffering, which can reach $5,000 or more. Now, I should at this stage refer to the one exception to the pain and suffering section, which is contained in Section 7 of the Act, which provides that where the injury to a person occurred while lawfully attempting to arrest an offender for an offense, or while preventing or attempting to prevent the commission of an offense, and while also being a victim of a crime of violence, the board may award compensation to the injured person for any other damage resulting from the injury for which damages may be recovered at common law. In such cases, our maximums do not apply. This anticipates, of course, special recognition to a person who is victimized as a result of a voluntary act of good citizenship. Generally speaking, We do not accept a claim for pain and suffering for a specific amount, although in a few instances this has been requested by counsel. I should further point out that even though an applicant does not claim for pain and suffering, our board will consider it on the grounds that an applicant may not realize that he or she may be eligible for same. And matter of fact, that happens in many instances where the person believes they're entitled to compensation, perhaps for the injuries themselves and loss of income, but don't think about the possibility that they may be eligible for pain and suffering. As a matter of fact, anybody who has physical injuries is entitled to something for pain and suffering, because there must have been some pain and suffering attached. I never heard of anybody having any kind of injuries without having some degree of pain and suffering. I would now, ladies and gentlemen, like to refer to pain and suffering for mental or nervous shock as defined in our Act. There were certain news reports recently, that you may have seen, with regard to claims for pain and suffering as a result of the murder of a family member. There were criticisms of the board in these instances because the board's decision, which distinguished between grief and sorrow and nervous or mental shock. It was almost impossible, if not impossible, an impossible task, to attempt through the media to get the public to understand the difference. The Act clearly defines injury as including mental or nervous shock. And previous decisions of the board have clarified that such an injury is compensable even to third parties who themselves have sustained no physical injuries as a result of a crime of violence. Let me refer to two cases which were dealt with by the board and which were classic cases in this respect. In Simone, file number 200-157, in case someone is interested in getting a copy, this was heard on June the 22nd, 1977. The applicant's wife was killed as a result of an arson-caused fire and explosion in premises where she was working. At the time of the explosion, the applicant was speaking to the victim on the telephone. Medical data attested to the applicant's physical and mental well-being prior to this incident. Within 1 year of his wife's death, that is, he had this shock because he was talking to her at the time, and he hears this explosion, and eventually somebody comes to the phone and tells him what happened. The medical report established that within a year, and I'm quoting here from the medical report, within a year after his wife's death, quote, he was transformed into a man obliged to seek help from the welfare department, who now classifies him as unemployable. His current condition is diagnosed as psychotic depression. End of quote. He was awarded $5,000 for pain and suffering, plus at that time, that was what, how many years ago? 6 years ago, plus $200 a month to a dependent for pecuniary loss. The first chairman of the board, the then Chief Judge Colin Bennett, put it very clearly and succinctly, in my view, in his written decision in the case of English, file number 100-84, which was heard in Toronto on October the 27th, 1971, and on March the 8th, 1972 in London. He wrote, and I'm quoting from his report, I am satisfied that Mrs. English suffered a genuine mental disorder brought about by the news of her daughter's murder, for which she is compensable, as an injury which constitutes a mental or nervous shock under the definition of injury in Section 1 of the Act. Her condition was distinguishable and much more serious than that of a parent simply grieving over the loss of a child. Compensation for mourning and for sorrow because of the loss of a loved one should not be awarded under the present legislation. I repeat that. Compensation for mourning and for sorrow because of the loss of a loved one should not be awarded under the present legislation. And it may be that the board in the future will be confronted with certain circumstances where it will be difficult to draw the line between, on the one hand, grief and sadness, and on the other hand, nervous shock and neuroses caused by the death of a member of the claimant's family. However difficult the task is, it will, of course, be the responsibility of the board to sift out the meritorious cases and to get at the truth of each case. End of quote. It seems to me that this is as clear and precise a description one could hope for on this particular subject. There are other cases of more recent vintage which deal with this matter of grief and sorrow versus mental or nervous shock. But the cases I have mentioned are very good examples of our board's approach to the problem. Now, ladies and gentlemen, I hope you'll forgive me for taking the liberty in closing my remarks with an expression of my view that the greatest value of the Criminal Injuries Compensation Board may very well be something other than the compensation of the some $2.5 million it's currently awarding annually. Over the years, some thousands of people, applicants, witnesses, spectators, student classes, etc., have seen the board in action. Many have expressed satisfaction of the board's work as one of the more humane elements of the criminal justice system. They see our procedure as a system which allows applicants particularly to express themselves in an informal way, in an informal setting, which permits them all the freedom necessary to relieve themselves of some repressed animosity against the formalities of the courtroom, within which they are quite understandably, and in most cases necessarily, required to limit their views, sometimes very passionately held views, about the circumstances which have brought them to a court and a courtroom trial, either as a victim or as a witness. Before our board, they find themselves for the first time in a setting where the focus is on the victim rather than on the offender. They may not always be as successful as they had hoped to be in respect of the quantum of the award, but by and large, we're satisfied that they feel a sense of satisfaction at being able to unburden themselves of some of those feelings they wanted to bring out at the trial, but which they were precluded from doing because of the more rigid formalities of the court. Now, I'm brought to mind here of the opinion expressed by an eminent psychiatrist who attended a hearing before our board as a witness in a rape case. Some days after the hearing, he expressed himself in a letter to the board. I have been treating this young lady ever since the offense for about 2 years, and I must tell you that the board has accomplished more for my patient in the 2 hours or so of the hearing than I have been able to accomplish in all the time I have been treating her. She had, for all of that time, been harboring a hostility against society, and particularly the criminal justice system, because of her feeling, and in my view quite justifiably, that the trial of the offender was conducted as though she had been put on trial rather than the offender. Her experience before your board enabled her to give her own version of what took place at the time she was attacked and on what took place at the trial, so that she came away from your hearing feeling that somebody was really listening and was sympathetic to the tragedy that had befallen her. End of quote in the letter. Forgive me if this sounds a bit dramatic. It's, I think, a perfect example, at least in the view the board takes, of the value of the work of the Criminal Injuries Compensation Board. Thank you very much.